with the program. Without any further ado, the man who made it possible, Mr. Ken Orlow.
Thank you. Okay, gentlemen, ladies and gentlemen, I have to slide my comments because this is going to take at least an hour, and I hope we get through the whole thing. It works very, very hard. You're about to say, this is a mock trial. This is not something that actually happens in the school. I guess it could happen. This case actually did happen. I went on the internet, I started looking for interesting cases, and I found one case. So it didn't happen here, but it did happen to someone. The general idea is that Ari Davidovitch, the defendant, raise your hand, plays out here, and this is make-believe, is being sued for playing a practical joke on Maor. The joke had something to do with a little fake mouse because Maor was afraid of mice. And he got really, really scared, and he fell off the chair and got injured, had to go to doctors, and now he's afraid to go into crowds. He's really scared. And they're saying it's all his fault. Look at him. Yeah. Okay. So now the lawyer's got to get him out of trouble. And these attorneys are trying to prove that he's responsible for all of this. But at this time, the main person, remember, right now you're in a courtroom. Not a gym, not a lunchroom, this is a courtroom. As soon as I introduce the judge, everything is in his control. If he asks you to leave, you leave. If he says you're talking, you're talking. He's in total charge. If the judge gives you a punishment, you do it. I will now ask everyone to rise, and I will have the judge introduce.
All right, Judge Flaks.
My name is Judge Keith Flats, and I'll be the judge of this case. It will be my decision and my judgment to decide if Mr. Davidovitch is responsible for all the damages caused. No. You can all sit down. Even though this is a mock trial, it will be regarded as a real trial here. I want and I need total silence from every single person here. That's including teachers too. I don't want any snickering and I don't want any outbursts or laughing. If I need to, I'll use my powers and I'll kick anyone out. Here's the basic case. Mr. Davidovitch set off a practice joke. He put a mechanical mouse at Mr. Ohana's party. When Mr. Ohana saw this, he was in shock and flipped back and broke his shoulder and his hip. Mr. Ohana is suing for two things, for physical damage and for emotional damage. The physical damage is obviously the broken hip and the broken shoulder. He's suing for $50,000, and he is suing for emotional damage, which is the emotional pain which was caused in his fear of the public and his fear of socializing, and that he's suing for $950,000. Begin. This court is in order.
Your Honor, today my fellow attorney Daniel Bauer and I will prove by a preponderance of the evidence that the defendant, Mr. Ari Davidovitch, is liable and should be held responsible for the physical and emotional damages done to my client, Mr. Maor Ohana. We are suing under the legal stances of strict liability and intentional infliction of mental distress. Strict liability means an ultra-hazardous act which may cause damage, and which the law holds the doer liable for, even though the perpetrator of the damage has used the utmost of care in the undertaking. Also, that the person committing such a tort is liable irrespective of the fact that he or she was not at fault. The defendant merely did something or failed to do something which is close enough in the causal chain to the plaintiff's damages, justifiably to hold the defendant liable. This basically means that if the defendant did an act that even may cause damage, and that he was even careful of what he did, he is still liable. This includes having the defendant closely linked in the chain of events which fits the claim of my client, Mr. Ohana. So now let's look at this chain. Ari Davidovitch placed a fake, wound-up mouse next to the defendant and clearly pointed it at him with the knowledge that he was terribly terrified of mice. He did this in front of all of his peers to add more pain and suffering. He then stood back to have a nice, good, clean laugh at the panic-stricken face of the defendant. Plaintiff, sorry. The only problem was that it wasn't a nice, good, clean laugh. As Mr. Ohana jumped onto a chair in fear of the mouse. And because of his franticness, which was brought out from the fear of this mouse, he then fell down, breaking a hip and a shoulder. Now, link 1 of this chain is Ari. Link 2 is the mouse, and link 3 is Maor Ohana. The defendant was directly linked in the damages that Mr. Ohana received. The mouse was the ultra-hazardous act that Mr. Davidovitch did. The mouse should be considered an ultra-hazardous act because he knew of the fear that Mr. Ohana had. He knew that he was afraid of mice. He deliberately did this in front of his peers to embarrass them. He knew exactly what he was doing. Under this definition, Mr. Davidovitch is liable. The intentional infliction of mental distress has more to do with the emotional damage part of our claim. It means, quote, a tort that allows someone to recover from someone's extreme or outrageous action and then causes the plaintiff suffering through serious mental distress. The rule for liability in such a case is when, quote, a defendant goes beyond all reasonable bounds of decency, end quote. This is exactly what Mr. Davidovitch did. He planned it all out to cause the most pain and affliction to befall my client. He took his biggest weakness and fear and blatantly, in front of all his peers, to cause extra pain to this act. Yes, this does go beyond all bounds of indecency. During the prosecution of the defendant, we will call offend the two parties to the stand, and he'll clearly state that he told the defendant, Mr. Davidovitch, that he really should have pulled this mean-spirited prank on someone who he knew had a personal weakness for mice. He told him it wouldn't be a good idea to do this in front of all his peers. He disencouraged him because he thought it was a bad idea. But Mr. Davidovitch persisted, hoping to see a man get embarrassed and scared. The outcome of this prank was a bruised, bone-broken man who from that day on may not ever go to a party, may forever be jumpy and scared of the littlest things for the rest of his life. May stop all socialization, parties, etc. The defendant mentally broke him down, and Mr. Ohana's personal expert psychiatrist will back up all these mental claims that I have just stated. The defense will bring their own psychiatrist, who will say that he's dealt with worse cases than my clients, and that they feel quicker. This witness should be disregarded for two main reasons. One, that he hasn't actually worked with my client. He's merely examined his case, and he cannot fully understand the depths of his case without having actually met him. And two, because each case should be treated and considered differently with the utmost of care and understanding, not making comparisons between different cases, not disregarding the fact that different people have different healing rates. That's not how psychiatry works. In fact, we will shred this psychiatrist's testimony to pieces. The defense will try to claim that the defendant's actual intent was not to harm anyone. But why should this even be addressed as an issue? If this prank had not been committed, there would not have been an accident like this. Who should pay the doctor bills, the physical therapy bills, the psychiatrist? Who should be blamed for this man's mental state? The plaintiff? No. He did not harm himself. He did not hurt himself. He was harmed directly because of the defendant's actions. Furthermore, according to the definition of intentional infliction of mental distress, intent is not an issue. Intentional, in this case, doesn't necessarily mean to harm someone. Doesn't mean that the intent is to harm him. It means that the intent is on doing the act, on doing the prank. The defendant was closely linked in the chain of events, and it was his own actions that brought this misfortune to Mr. Ohana. The defense will try to sway you from this verdict of liability by stating that there were constant pranks going on between each other. But again, why should this be addressed as an issue? There were damages that should be compensated for. Also, who cares about any of the other cases? They're completely irrelevant, because we're talking about this case here and now. What happened in those cases have absolutely nothing to do with this case. We will then finally finish our round of witnesses with Mr. Ohana, and he'll take you from the fun-loving life of a relatively normal person to a scared little man with mental problems that are incomprehensible to that of the average person. Mr. Davidovitch viciously, yes, viciously, brought down Mr. Ohana to this stage of mental instability. He does not socialize and does not take any calls. In his little mind, this could always happen again. That means more pain, more pills, more help. To us, this may seem a little bit like an overreaction, but imagine, just imagine, having your best friend stab you in the back by taking your one weakness, your Achilles heel, and orchestrating a specific scenario where the most pain and affliction will fall upon you. Why else would what Mr. Davidovitch have chosen to do in front of all Mr. Ohana's peers? He knew exactly what he was doing. And I personally think that this goes beyond all reasonable bounds of decency, that this is an outrageous act. To attack his only weakness, knowing that was what would pain him the most, and then to mount that by including all his friends to laugh at him and to enjoy his immediate pain. So why is jumping onto a chair so unforeseeable? Well, it's not. This is why Mr. Davidovitch is liable, because he degraded a man for his own personal interests. He brought him down to this pitiful excuse for a human being. If you don't find Mr. Davidovitch liable, then I don't know what this world has come to.
Honorable Judge, we are gathered here today based on preponderant evidence that myself and my attorneys will use today to prove that our client, Mr. Ari Davidovitch, is not liable for Mr. Maor Ohana's very unfortunate accident. One night, at a party thrown at one of their friends' house, Mr. Davidovitch showed Mr. Ohana a wind-up mouse, and suddenly, after seeing the mouse, frightened, he started to scream, ran across the room, jumped up onto a chair, and fell backwards, and ended up breaking a shoulder and a hip. At the moment that Mr. Ohana started to scream, our client, after seeing that reaction, tried to calm him down by telling him it was just a fake mouse. And after Mr. Ohana fell, our client rushed to call 911. To conclude, this was just a joke that Mr. Davidovitch played on Mr. Ohana. He had no intent at all to hurt him. They continuously played practical jokes on one another. We have a psychiatrist who will testify that he examined this case, and he will also say that he has worked with patients like this and worse, and they have recovered at a much quicker rate. We have also brought a friend of the two that will say that this was a continuously played joking game to see which one could outdo the other. He will also say that Mr. Ohana recently pulled a prank in which he put hot sauce on Mr. Davidovitch's slice of pizza, with full knowledge that Mr. Davidovitch did not like hot, spicy sauce. Unfortunately, this time someone got hurt, although there was no intention for anybody to get hurt with this joke. We will also show that based on the law of
proximate cause, it is unjust to hold the defendant responsible for all the damages brought to court by the plaintiff. The court must look only to the foreseeability of the harm that resulted from the defendant's negligence. This means that if anything, the defendant should only be responsible for damages that one would expect in this situation and not be responsible for damages, especially emotional, that already existed.
You promise to tell the truth, the whole truth, and nothing but the truth? Yes.
May I first witness?
Mr. Schwartz, do you notice anything out of the ordinary at tonight's incident? Yes. Could you please specify to the court what this was? Mr. Ari Davidovitch.
That unlike in the past, this was a mock trial. But the only thing that was mock about it was that in fact these things did not happen. But the judge is not aware of all the things the witnesses are saying and the strategies the attorneys are using to make their case. So he has no clue of that, and therefore his decision would be as if it's a real case. Okay, continue.
Okay. Next witness.
We call Ari Davidovitch to the stand.
Please use about 6 inches from
Hands on the book, raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth?
Yes.
Everybody has to speak up, even when it's night.
Mr. Davidovitch, what happened that night?
We were at a party, and I went up the mouth, and I let it go, and Maor got scared, and he jumped on a chair. The chair flipped over, and he got hurt.
When you saw he got hurt, what did you do?
Objection is irrelevant. Doesn't matter. He still got hurt.
It doesn't matter to, so we can know what his intent was coming into it. I didn't know what to do, so I called 911. What? I called 911. Called 911.
So you weren't laughing, right?
No, I wasn't.
What was the greatest practical joke that Mr. Ohana played on you?
He gave me a piece of pizza with hot sauce on it, and I ate it, and I burnt my tongue. What? Say it again. Gave me a pizza with hot sauce on it, and I ate it, and I burnt my tongue. If we put pizza in front of you today, would you be scared? If we put pizza in front of you today, would you be scared? No, I wouldn't.
What was Mr. Ohana's reaction when he saw you?
Objection, Your Honor, irrelevant. What we care about Mr. Ohana's, what we care about his reaction in that case, what should we compare these two cases with their reaction?
Because I want to compare that he, Daryl agreed tried to hurt him by like making his tongue burn, and Mr. Davidovitch did not.
Stand.
Did you have any intent to hurt him? Did you deliberately try to hurt him?
No, I didn't want to hurt him.
No further questions.
Mr. Davidovitch, was this about revenge? Was this about revenge?
No, we always play jokes on each other.
It was just about playing jokes?
Yes.
When you came coming in, did you want to hurt him at all?
I didn't want to hurt him, no.
But did you want to embarrass him?
No, I didn't want to embarrass him.
Fix it close.
I didn't want to embarrass him.
Then why'd you play the joke at all?
Because that's what we always do. We always play jokes on each other. Yes.
You didn't want to hurt him, but you played the joke in public. Why did you play it in public?
Because that was where I thought of it and did it.
You thought of it right in public, right then and there.
No, I had to get before, so I thought of it before too.
So you thought of it before, but you did it in public, but you didn't want to get him embarrassed in front of a bunch of other people. Is that what you're saying?
Yes.
No further questions, Your Honor.
You guys gotta work it out. There's more for you. They're ready. Then you can come back.
Where did Mr. Ohana give the pieces to you, the hot dog?
In public.
Your friends were there, right?
Yeah.
So you can say the same thing, that he tried to embarrass you, right?
Yes.
No further questions.
Yes.
Mr. Davidovitch, why did you pull this mean-spirited prank on Mr. Ohana?
Because I wanted to get him, because it was always like that. We always play jokes on each other.
So, in your opinion, did you think it would be funny?
It was supposed to be.
It was supposed to be. So then what happened that made it not funny?
He hurt himself.
He hurt himself? Or was it your actions that directly resulted in him falling off the chair and hurting himself? Was it, in essence, was it really him hurting himself? Or was it your actions that made him hurt himself?
It was my actions, and he fell over.
So because of your actions, he fell over?
Yes.
No further questions at this time.
Mr. Davidovitch, walking in, did you have even the notion in your mind that Mr. Ohana would hurt himself?
No.
What about being embarrassed?
I didn't want to get embarrassed either.
But walking in, was there a possibility of him being embarrassed?
What?
Walking in, but when you decided to do it, was there a possibility of him being embarrassed?
I think so, yes.
There was, and he still went on to do it?
Yeah.
Why?
Because it was a joke. He wasn't really supposed to get hurt.
Did you think the possibility was big or little? You thought there was a big possibility? Or
Him getting scared?
him getting embarrassed, or a little possibility?
It was a little possibility.
Is that all? Last time.
When you played this prank on him, you knew that he was terrified of mice, am I correct?
Yes.
So you knew that he would panic.
Yes.
And when someone panics, are they predictable?
No, but I didn't think he'd jump over a chair.
If someone is unpredictable, what does that mean?
Not even tell what he'll do or something.
You can't tell what they're going to do, but you didn't think he would do something. So was he predictable or not? Okay, and with this pizza pie, with the hot spices in it, burned your tongue. Can you compare that to breaking someone's shoulder and hip?
No.
No further questions, Your Honor.
Mr. Davidovitch, why didn't you use a real mouse? Why did you use a fake mouse instead of a real mouse?
Because I thought he'd realize there's a fake mouse.
Okay, that's it. What? If the reason why you only use a fake
mouse as opposed to a real mouse is because he didn't really want to scare him or hurt him so much. Why do you pull the prank?
Yes.
Mr. Davidovitch, will you please answer the question?
Yeah. Because we always play jokes on each other.
So that justifies damages done to my client, because you always play jokes on each other.
No, it doesn't.
If it doesn't, then shouldn't he have some compensation from you? Shouldn't you have to pay him for the damages if it doesn't, if what you just said is true?
Why should I be paying? He burnt my tongue. I don't see him paying.
And how much damage is done to your tongue?
It burned.
It burned. And how long did it stop burning?
For about 2 weeks.
2 whole weeks? Really? Wow. Well, did you know that my client has been in therapy for 6 months, had a broken hip and shoulder, and will be continuing in therapy, has been taking pills twice a day, every day, 7 days a week. So I think that's a lot more than 2 weeks.
Is that a question or that was that?
Is it or is it not more than 2 weeks of your burning?
Take your speaker to the end. Is that all?
Your Honor, I think it is clear that today we have proved that not only is he Mr. Davidovitch liable for physical damages to Mr. Maor Ohana, but he is also liable for emotional damages to Maor Ohana. The strict liability, or the liability that he is in charge of this, it was his close link that he pulled the mouse out on Mr. Ohana. It was his fault that he did that. He did it on purpose, knowing that he would be embarrassed somewhat. He couldn't predict whether or not he would jump onto a chair. I think that proves the strict liability part. The intentional infliction of mental distress, he knew that he would be embarrassed. Usually when people are embarrassed, they get a little bit more to themselves. They get a little bit more solitary. They don't go into public as much. That's a bit of a mental distress, also proven by the amount of medicine he takes. The other cases, like the burnt tongue, well, he himself said that it's not relevant. And it's not relevant. And the reason why he did in front of other friends was he wanted to get pain. He wanted to get pain from him. He did it in front of his friends so that way he would get hurt. Otherwise, he would have done it alone. He would have had a good laugh by himself instead of it with his friends. So I think that today my co-lawyer and I, Lobel, have proven that he is liable and should pay for all the damages he's caused.
Judge, we came here today to prove that our client, Mr. Ari Davidovitch, is not liable for the damages done to Mr. Maor Ohana. You might ask yourself, why is he not liable?
Andrew, out. Out. Get out.
You might ask yourself, why is he not liable? Our answer to that is, these emotional damages were arisen far before this incident with our client. How can you say Mr. Ohana was afraid to socialize that the testimony by Mr. Jeremy Schwartz that he did?
Our answer to that is that Mr. Ohana seems to be making the damages far worse than they really are. Because if he can't socialize, why is he in this courtroom today? Also, based on the law of proximate cause, a client cannot have possibly expected or foreseen that this would be the reaction of the plaintiff. Mr. Ohana, tell the difference between a dollar and
No whispering to other people.
say that to me, don't tell it to your friends.
Understand what he's saying.
Be more clear. They also, based on the law of proximate cause, our client could not have possibly expected or foreseen that this would be the reaction of the plaintiff. Mr. Ohana, tell the difference between a doll and a certain object and a real object. Why could he not have been able to distinguish a wind-up mouse, which looks very much like a child toy, from a real mouse?
That we're putting it in your hands, that you're the jury. You've heard the whole case. You know he's being sued for physical and emotional damages for certain amounts of money. What's the amounts on the physical?
The amount of physical is
$50,000 they want from him for physical damage, for hospitals, for doctors, for psychiatrists, physical therapy. And $950,000, which I will make in 10 lifetimes, $950,000 they want from you for emotional damage that they claim he can't even go out in public, but you're doing nicely. So you are the jury. The first question, you see, he doesn't give them any money if you think he's not responsible for any of this. So the first question that the judge has to think about, is he responsible for his physical damage? Is he responsible for his emotional damage? Or was he in that case before this happened? What's up with that? Yeah. Did he have an emotional problem before this whole thing about ice? Or did he cause all the trouble? The first question I'm going to ask all of you, including, Young.
If he was
loud so everyone can hear you.
If he was afraid of mice before this happened, and he was still able to go out into public and socialize with people, such as in the pizza shop, then how can you say that? What's it called?
How can you say?
How can you say that he should go out that he had problems with the mice before? I mean, besides that, if he did have problems with mice before, he'd be going like this constantly.